Good evening, everyone.
Good evening, sir.
Yes. How far have we gone with distribution of topics?
Good evening, sir.
Good evening.
Yes, sir. We have 4 groups that we are distributed topics to from the last class, and you said after our class today we are going to continue the distribution of the topics. So we have 4 groups that are supposed to present. So group 1 to
I
group 4.
understand that the first paper is even ready for presentation.
Yes, sir. It was submitted to your office and also by electronic means through WhatsApp. But for only group 1, but group 2, 3, and 4, I'm yet to receive their copies.
Okay. So what do we do today? Do I discuss do I introduce the remaining topics? So that as from next week we start taking presentation.
Yes, sir.
Yes, sir. Introduce the topic, sir. Introduce the topic, sir.
Okay. It's all right. I'm coming. You all have I think I sent to you the seminars.
Sir, you only sent 1 to 4 to us. You've not given us the rest, sir.
Okay, but I gave you the complete list.
Yes, sir. The course outline.
Yes.
Trying to check.
That's what I'm trying to get from my laptop. What is topic 5 there?
Okay, sir. Sorry, sir. Just a minute, sir. Sir, just a minute.
Okay.
Yeah, topic 5 is conflict of law, the conflict of law process and technique.
Oh, okay. No wonder. No wonder I said I was going to postpone it. It's going to be a bit technical. But, that topic is the topic is directed towards letting you understand the procedure or technique of identifying the conflict questions and answering them. Okay? Often, the judge is confronted with conflict of laws when he is least prepared for them. Conflict of law issues when he's least prepared for them. But the ability to identify when you have any of the conflict questions arising, as well as the ability to identify how the questions will be answered, is a special skill that need to be acquired. Those who would introduce the course to us will tell us that the course will answer 3 questions: choice of jurisdiction, choice of law and recognition, and enforcement of foreign judgment. Choice of jurisdiction and recognition and enforcement of foreign judgment are pretty straightforward. They do not arise indirectly. You would have issues having to do with jurisdiction when somebody raises the competence of the court to attend to a case. Not generally, not because of any other thing than because when the venue is not proper. As in, for example, where facts throw up connection with 2 or more states, anyone could commence an action in any of the states. But the other party would then say, why are you suing me here, not in the other states? So you know immediately when that is raised that the issue is the issue of choice of jurisdiction. That is whether of the 2 or more connected states, each particular one, the forum, is the proper one where the action ought to have started. So again, enforcement of foreign judgment is a straightforward issue. Somebody must be armed with a judgment of another country, which he wants to enforce in our forum. We then look at our own forum rules on recognition of foreign judgment as well as enforcement. So directly, you don't need a lecture to know when the question before you is that of enforcement of foreign judgment. But when it comes to choice of law, you first have to identify that this is a choice of law question. If a forum court is being asked to determine disputes, the facts of which relate principally to some other territory, the issue would then arise: which law, which substantive law will the court use in determining the dispute? The role of conflict of laws then is to direct that court as to which law. Some of the time, the court will be directed to apply not foreign law, but foreign law. And some of the time, our conflict rule will direct the court to apply foreign law. So under this technique, we want to know how does the court arrive at the correct substantive law. Those who don't know this subject area, they go into it with an assumption that the question of jurisdiction and question of law are the same. In other words, they assume that once you conclude that your court has jurisdiction, that is, that your court is the proper forum under the choice of jurisdiction question, then you don't ask another question again. Just apply your court's or your forum's law. That is far, 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 far from the correct answer. It is a capitally wrong answer. You might answer the forum question, the jurisdiction question, in favor of your forum, but that does not preclude you from asking the law question again. And the answer to the law question might suggest that it is foreign law that you will apply in resolving the dispute. In doing so, the judge is not abandoning his responsibility as a foreign court judge. He is still applying foreign law. But the aspect of foreign law that is applying is private international law of conflict of laws. Every country, every legal system, every legal district would have our own answers to questions that are basically international. So there is nothing like a universal conflict of choice of law rule. What we have is every legal system has our own connecting factor that she uses. When you apply that connecting factor, even if it leads you to foreign law, we do not take it that you are applying foreign law. We take it that you are applying foreign law, the whole of foreign law, including its conflict rules. So, if there is a dispute between two persons and the facts throw up connection between two countries, whether including our forum or not, and you now apply our own connecting factor to say it is the law of state X that will govern this dispute. Okay? By doing so, you are not applying foreign law. You are applying foreign conflict rules. It is foreign conflict of law rules that has directed you to apply foreign law. So that is the logic. So how do you go about it? The first thing you must identify is what is called characterization or classification. What do you mean by characterization or classification? You look at the facts, then you identify what subject area of law do the facts throw up. And why do you have to do that? You have to do that because every country's legal system determines the proper connecting factor with reference to the facts. There are some disputes that you regard as event disputes. Event disputes. This thing happened. Then you ask, where did it happen? Okay? There are some disputes that you call status disputes. Okay? Status disputes like marriage, succession, custody, legitimacy, legitimation, validity of wills. The question you ask is, where is the propositor's domicile? So that if you have to determine, for example, who inherits the estate of a person who dies leaving properties across the globe, the answer will be apply the law of the place where the person was domiciled. if you have to determine the validity of a marriage, if the issues border around capacity, that is maybe prohibited limit of affinity, prohibited limit of consanguinity, and what have you, countries have different rules on that. There are legal systems where first cousins are permitted to marry. There are other legal systems where that is not allowed. And so, how do you determine in a conflict of law situation whether it is the law of the country that prohibits first cousins to marry or the law of the country that permits them that you apply, both being having some connection with the issue? The answer will be, the connecting factor will be domicile. Where are the couples domicile? Okay? So even if they are before your court in Nigeria, if the facts throw up the position that they are both domicile in, say, a Muslim country, say Pakistan, where the applicable Islamic law permits first cousins to marry, you find yourself endorsing that marriage, not because our own marriage ordinance permits that degree of, what do you call it, that degree of consanguinity, but because they are not domiciled here. They are domiciled in a country where their marriage law permits it. So the connecting factor is domicile. Okay? So we have event disputes. The dispute that you can categorize as event, you apply the law of the place where the event occurred. We have disputes that you can categorize as relating to status. You apply the law of the domicile of the parties. We have disputes that have to do with agreement. You basically apply the law that the parties actually intended by the agreement. And when we get to law of contract, you see how you arrive at that intention of the parties, depending on the type of agreement you are talking about. Okay? So, looking at it in that way, what a court would do to arrive at the territorial law or legal system that will resolve a dispute, the first thing is characterize. By characterization, we mean you put the facts under a subject head. Oh, this fact shows up tort or civil wrong. Oh, the facts throw up status. Oh, the facts throw up disputed agreement. The reason why you are doing so is because connecting factors differ from subject to subject. So the first thing you must do is classification or characterization. So the next thing after you have arrived at the conclusion that the dispute relates to a particular subject area is to identify the connecting factor for that subject area, which I have already analyzed to you. If the dispute is an event dispute, you want to say that apply the law of the place where it happened. If the dispute is a status issue, you want to say, we here in Nigeria and common law, we want to use domicile. We want to say, okay, the propositor, where is it domicile? If it's domicile in statewide, then it is statewide law that will apply. If the matter is an agreement, a group of matters that fall under agreement or contract or what have you, you want to apply the law that the parties intended. And there are at least 3 formulas for arriving at the law that the parties intended. So there is no compulsion for you to apply forum law. That's what we are saying. And that is why we point out errors of the courts. It's very easy to point out errors of Nigerian court because you see them assuming that the only place where you can litigate a matter is either where it happens or the legal district to which the parties are connected. That is not correct. In Amanambo and Okafo, an accident that occurred, a fatal accident that occurred in northern Nigeria, but litigation took place in eastern Nigeria. And the question was, Nigerian law requires that you must plead the fatal accident statute specifically for it to apply. So the claimant had originally pleaded fatal accident law, I think of northern Nigeria, whereupon the defendant objected, saying that he could not have pleaded northern Nigerian statute before an eastern Nigerian court. Unfortunately, the counsel to the claimant thought that he was cornered. So he brought an application to amend, pleading fatal accident law of eastern Nigeria. The court gave him judgment. The matter went on appeal. You know what is Supreme Court? Because the argument of the appellant was that it was not possible, it was not right, it was not legally valid for the Eastern Nigerian court to permit the Eastern Nigerian statute to be pleaded in respect of an accident that occurred in northern Nigeria. Okay? In my several write-ups, I criticize the judgment of the Supreme Court, saying that it's a clear lack of understanding of the conflict process. If an accident, if you treat Eastern Nigerian legal system as a distinct legal system from Northern Nigerian legal system, then if you are litigating an accident that occurred in Northern Nigeria, that will be an event dispute. The rule is apply the law of the place of the event. So when the man pleaded the fatal accident law applicable in Northern Nigeria, he was not wrong. He was not wrong. He should have stood his ground that, yes, under the principle of lex loci delicti commissi, the law of the place where the tort occur is what I will plead. But because he didn't know, he surrendered to the law of Eastern Nigeria. But even at that, the Supreme Court should not have thrown away his case. Okay? The Supreme Court should not have thrown away his case, as I've argued elsewhere. But the point is that his basic knowledge of conflict technique that made the counsel to the claimant to be shaken by the preliminary objection. A tort is an event wrong. The connecting factor under our own system is the law of the place where the event occurred as a general rule. There are exceptions. We will discuss the exceptions when we get to law of thought. Thought in conflict of laws. Okay? So that is as simple as conflict technique goes. And is one of the papers. If you are lucky to be allocated group 5, your tax is much straightforward than those who will be allocated group 6 and 7. Group 6 and 7 would discuss 4 technique, 4 very technical technique topics. We call them characterization, time factor, Rouvoir, and there's a 4th one. What did I call the 4th one in your something? Hello?
Hello.
Yes? Subsidiary question. What did I call it? Check the...
Incidental
I don't know what...
question.
Incidental question. Incidental question. So what do we mean by this 4? Characterization, I've explained it to you before. But characterization is sweet. It's very sweet when it is not complicated. When it is it sweet? It's a sweet issue to discuss. When the characterization of the subject S of the lex fluoride is the same as the subject head of lex causia. In other words, if state A and state B are involved, and in both state A and state B, the fact of the dispute will be categorized as torts, then you don't have a problem. Because when the forum directs you to go to the lex causia, you won't need to ask any further question in the lex causia than to know what their law on the subject says. But imagine a situation where the forum categorizes the matter as tort, but the lex causia sees it as crime. As in, for example, the tort of libel. It's not every country that permits civil action in respect of tort of libel. There are some countries that treat libel as purely a criminal matter and do not permit civil litigation in respect of it. Okay? So, if a case is going on in Nigeria, and it has to do with libel published in, say, Brazil, the court looks at the facts and says, look, these are questions, the fact in dispute or the dispute throws up libel. Libel is an event wrong. The connecting factor is lex loci delicti commissi, law of the place of the thought. Where was the libel published? Brazil. So let me just go to Brazil and look at what Brazilian law says about this. On getting to Brazil, you find that there is nothing like thought of libel. Libel is a crime in Brazil. So what do you do? That's what we call the problematic characterization issue. That is where the lex fori, that is the forum court, the law of the forum, does not regard the dispute as, does not categorize the dispute the same way the lex corsia categorizes it. So immediately you have a problem. And conflict expert will then begin to cancel us. And the council will not neither be here nor there. It will be like when politicians are debating policies. At the end of the day, you won't be satisfied with any. Because every so-called good policy has alternative. And there is no policy that is totally bad. So academics will then, experts will then begin to suggest alternative. Okay, do you characterize by lex corsia? You say, okay. The facts shows connection with Brazil. I am going to characterize according to Brazilian law. People will criticize that. Say, you are putting the cart before the horse now. They are putting the cart before the horse. How can you characterize by the law of the foreign country? Yet we have seen that characterization by lex fori does not solve your problem. So several other theories will come. Comparative law theory, fair media theory. So if you are the one writing on characterization, everything you need will be in basic text, but you will have to explain it to us. Okay? You have to try and explain it to us. My own conclusion has always been that there's no foolproof solution. That's my own conclusion. But let's look at all the options that are available. So that's characterization. Then we have the next issue. We have incidental question. What do we mean by incidental question? We are talking about connecting factors. And we are saying that connecting factors are attached to the subject edge. See, if it's an event thought, apply lex loci the delictic commissi or lex loci celebrationis. If it is a status cause, apply the law of the place of domicile. If it is an agreement-related issue, apply the intention of the parties. If it has to do with property, whether property has been sold or not, apply lex titus. Straightforward idea. But some of the time, there will be more than one issue. One issue will be the main issue. The other one will be incidental. Typical example. The case before the court is who is entitled to inherit Mr. X, who from the fact is shown to be an international, was shown to be an international person with properties in many places and haven't lived in many places. Okay? You say, okay, apply. That's a status question. Apply domicile. And domicile as a connecting factor takes you to say statewide. Okay? But the secondary issue arises. The status of Mrs. Y or Mrs. X the wife of the propositors to inherit? That's a separate question on its own. So you now have two questions: the right to inherit and the validity of marriage. Each of these questions could have come on its own as a separate course of action. But you as a judge, you have the hard luck of having to determine the two issues together. What do you do? Do you subject the two issues to the separate technique process? You might find that state Y is the domicile, but the marriage was not done in state Y. The marriage was done in state X. And the issue thrown up is formal validity of marriage, the connecting factor of which, because formal validity is treated as an event thing. So the connecting factor will be lex notis ereditioris. So are you going to apply the law of state X to determine the formal validity question? Or are you going to say that, well, since state Y is the connecting factor for the main issue of inheritance, the issue of validity of marriage will also be determined by either state Y internal law or state Y connecting factor. So the question of validity of marriage in that example becomes an incidental question. If you read your basic test, they will give you direction on how to identify an incidental question. The first one will be that there must be a principal question, major question, whose applicable law is foreign law. Then there will be an incidental question that could have arisen on its own separately, but in this particular instance is a subsidiary question to the main question. The third option is that your conflict of laws rule will then direct you, give you two options. One, subject the incidental question to the conflict rules of the lex causa of the major question. Or two, subject the incidental question to your own conflict rules. Okay? So when you are discussing this, you will look at the textbooks and see which approach is predominant. The very basic first thing is to identify what is an incidental question. The second one is, what do the courts do? Can you find any uniform approach of the courts? If you can, what is it? If you cannot, tell us that the courts have no uniform approach and all of that. So that's incidental question. The third issue is what we call time factor. Time factor. This one addresses the issue of changes in law. There are so many possible changes. There could be a change in the substantive law of the lex causa. There could be a change in the conflict rules of the lex fori. There could be a change in the conflict rules of the lex causa. Okay? So the forum court is at a dilemma. What do I do? If, for example, after the incident that occurred abroad in an event dispute, in a dispute that we categorize as event dispute. After the dispute has occurred, the law changed. Either damnifying the otherwise innocent actor or declaring as free from guilt the otherwise innocent actor. Does the forum say that, look, as at the time this event occurred abroad, and my connecting factor says I should apply the law of the foreign country where it occurred. This was the law then. I'm going to disregard the subsequent changes in the law. Or does the forum apply when once the forum connecting factor has directed it to the foreign country, the court just applies the law of the foreign country as it is presently? That is the question of time factor. You will find that our own position on the matter is not constant, irrespective of subject matter. So those who will write on this one will give us the different perspective. If it is talks, if it is marriage, if it is contract, if it is property, etc., what is our attitude? Okay? Typically, we use thought as an example for you, and we use the case of Phillips and here to demonstrate to you that time is not a factor in the subject area of thought. Phillips and here is the case where the governor of Jamaica was trying to foil a rebellion or a protest. He then caused people to be arrested, people to be assaulted, and all of that. But in order to avoid being sued, he came up with an indemnity decree. In an indemnity decree like what was very common during military era, where they will say anything they do is not to be questioned, has no consequence. That was the type of decree he came up with. The meaning is that on the very day he committed those wrongs, even Jamaican law will hold him liable. But if you attempt to go to court after the indemnity legislation was enacted, backdating, because the indemnity legislation specifically referred to what was done before that decree was done. If you go to court in Jamaica after that date, the Jamaica court will be bound by that statute, and he would therefore say the governor is blameless. But what happened was that some British men waited for the governor to end his tenure and return to England. And when he returned to England, maybe years or months later, they sued him in the English court. So the challenge of the English court is, look, these people are complaining basically about event wrongdoing, which will be governed by law of the place. Okay? The place was Jamaica. But Jamaican law, as it was when the event was done, is different from Jamaican law as of today. Because if you are considering Jamaican law as of today, you have to include indemnity legislation. And the indemnity legislation has already freed the man. So which one are we going to apply? At the end of the day, the court said it will apply the whole of Jamaican law, including the indemnity decree. And therefore, we, as analysts, we now say that is the reason why we say there is no time factor in the subject area of tort under our legal system. Had it been there is a time factor, we would then have amended lex loci delicti comici to lex loci delicti comici at the time of the tort. Time becomes a factor. Okay? But on this occasion, we say time is not a factor. If our connecting factor leads us to Jamaica, then the law we will apply will have to be the whole of the Jamaican law, including the retrospective amendment that was done to it by freeing an otherwise blameworthy person from blame. But that is the way it is for tort. It doesn't mean that that's the way it will be for other wrong. So when you read your book very well, you will see some other subject areas where that is not so. You will see other subject areas where the pattern in frames and hair is followed. So that's what we task you to do. Then the last technical issue we normally discuss is the one we call RUVOI. RUVOI is spelled R-E-N-V-O-I, but it's pronounced RUVOI. What does RUVOI mean? We have said that connecting factor will direct you sometime to foreign law, and you apply that foreign law, not because you are abandoning your responsibility to apply foreign law, but you are applying the whole of foreign law, including its conflict rules. So we ask, what is foreign law in that context? Because foreign law could mean the internal law of the lex corsia. In private international law circumstances, it could mean also the whole of the law of the lex corsia, including its conflict rules. So countries have different approach. So two countries might have the same connecting factor, but if their rubric concept is different, they might end up arriving at different state law to govern an issue. I give you an example. Let's take the question of inheritance. If a man who is a national of state X, but domicile is state Y, if the inheritance of his estate becomes an issue in Nigeria, okay, we are basically going to, it's a status matter, so we are going to apply domicile. As they apply the law of the place of domicile of the propositors, and we said the man was domiciled in state X, even though he's a national of state Y. So we say apply the law of state X. But what is the law of state X in the context of our RUVOI policy? If our RUVOI policy is what you call rejecting RUVOI or internal law theory, then our wahala would have ended the moment we arrive at state X. We just ask the expert of state X law on the matter to come and brief us what their law is, and we apply it, and that's the end of the matter. But if our RUVOI concept is not rejecting RUVOI, then we maybe have nothing to do with the expert of the internal law of state X. We will call the conflict of law expert of state X. to come and tell us the conflict rules of state X. And it may well be that whereas our own connecting factor is domicile, state X connecting factor is nationality. So in that wise, we may have to apply the law of statewide. Not because that's what our own law directs us to do, but because our own law directs us to state X, and the complete rule of state X directs us to statewide. So you have different categories of rule. Those who write paper on it must explain each category to us. You have rejecting rover, which I've already explained to you, otherwise known as internal law theory. You have partial rover, and partial rover are of two types, by remission or by transmission. By remission simply means that the complete rules of the lex concierge has thrown the matter back to us, so we will apply our law. By transmission means that the complete rules of the lex concierge has thrown the matter to another country, so we will apply the law of that country. So we have partial rover by remission, partial rover by transmission. But that's all. That's not all. The one that is searched by analysts, rightly or wrongly, to be our own policy on the matter is what is called double rover or total rover. This one simply has assumed that even in applying the company rules of the lex concierge, we will stick to its rover concept. And experts have described that as a situation where theoretically the court is situating the dispute lock, stock, and barrel in the lex concierge and doing exactly as the lex concierge would have done. So usually what we do is this more technical question, we divide them into two. We say one group should take two, another group should take two. In very large classes, you can say take one each. So we divide them into four after we have received an introduction on the general discussion of technique. So that is topic 5. You see why I said that topic 5 is not a one topic. You have to divide it minimum of 3, maximum of 5, depending on what the size of the class is. So you can say that the technical questions, one group you take each one. So you have 4, plus the introductory discussion on the conflict technique and process. So, Governor, have you allocated this to people?
No, sir. For topic 5, no, sir. We have only allocated one to group topic 1 to 4. But for topic
What
5,
is the
no.
size of our, how many people are you allocating to each topic?
For each topic, we have 5, maximum of 5. We have 5 students per group, sir.
I'm asking, what is our size in the class so far?
We are about 1.
One can
We are about 109, sir.
but I told you to lock the thing after 60 or 70 now.
It is those who attended. It is those who attended class. That's what you should be about, not the number on the platform.
But the other time when we were in class, I think we were not more than 60 now. And we said maybe we will get 6 or 10 more.
Sir, according to the according to the attendance, presently now we are 77. But according to our group, our WhatsApp platform, we are 109. So
So people
if
are
you are
just,
going,
some people are just joining, they are not interested. Anyway, divide it into 5. So that if
okay,
you have 5, this topic alone will be able to accommodate 25 people.
okay, sir.
Huh? So you know
Yes,
how
sir.
you do it. The general introductory discussion, which is technique of arriving at applicable law. Then you take characterization, problematic characterization, incidental question, time factor, and RUBA. So that's 5. So what is topic 6?
Topic 6 is exclusion
Of
of
otherwise
otherwise
applicable. That one I say
applicable
to what I
foreign.
don't want to bore myself with that one. Take any basic text. What we are trying to discuss under this one is that sometimes when our connecting factor directs us to a less causia, our forum court will not accept that the law of that less causia. In rejecting the law of the less causia, we either replace it with our forum law or we end up not recognizing the cause of action itself. Okay? So what are those reasons? What are those reasons on which otherwise applicable foreign law may not be accepted? The very first one we normally discuss is failure to plead and failure to prove. What do we mean by that? Foreign law is a fact, not a law. So if your cause of action depends on foreign law and you fail to plead it, there's no way the court will apply it. But that does not mean that the court will throw away the case. The conflict common sense is that it is at your option as a litigant who will benefit from foreign law to rely on it or to rely on foreign law. So when you do not plead or prove foreign law, the court does not throw the case away. The court applies foreign law. So that is the second mistake of the Nigerian courts, Namanaba and Okafor. If an event wrong occurred in northern Nigeria, it is normal for a litigant who will benefit from northern Nigerian law to plead and prove northern Nigerian law in eastern Nigerian court. But if he does not, the conflict justice says apply foreign law. It doesn't say throw away the case. Now look at the fact of Amanambo and Okafor. The Supreme Court threw away the case simply because in the opinion of the Supreme Court, he ought to have pleaded northern Nigerian law. And so, having not pleaded northern Nigerian law, eastern Nigerian law could not apply. That's not correct. If he doesn't plead northern Nigerian law and plead eastern Nigerian law, he has opted for the forum law. It is the other party. If he thinks that northern Nigerian law will better his lot, that will go and plead it instead of saying that you are pleading forum law for foreign facts. So the two errors in Amanabo and Okafor is the failure to understand that the question of jurisdiction is different from the question of choice in law. And the second one is the failure to understand that failure to plead or prove foreign law is not fatal to any case. It just simply means that you will apply foreign law. And if the other party thinks that foreign law will offer him a defense that he does not have under foreign law, it will then become his own duty to plead it. So that's the first one. The second one is when foreign law is categorized as penal, crimes are local offenses. They are local offenses. You don't enforce foreign criminal law. Okay? You will see the cases on that. You will see cases where the authority of a particular country ordered for they set up a committee that found somebody guilty of treason and said that his property, wherever located, should be seized. But the man has property in UK, and on the basis of that, their own decision, they want to give effect. They want his property to be seized or to be given to his country of origin. Of course, the English court said that penal order of a non-court, even if it's that of a court, has no effect in their own country. Okay? If you read Professor Agbede, there's another case cited. There's another case Professor Agbede cited. Ademi Louis and I think Attorney General of Western Nigeria, where somebody was by an edict of Western Nigeria condemned and his assets anywhere in Nigeria seized. The question was whether a Lagos court would lend assistance to a Western Nigerian government to give effect to that, to seize the man's property located in Lagos. And the answer of the court was no. Rely on this principle. So, as a general rule, it's an error. It's an error to rely on either foreign crimes or even foreign conviction to say you want to disqualify anybody or you want to, okay, unless maybe that is what the Constitution specifically says, because crimes are local offenses. They have no life beyond the place where they occurred. So if ordinarily the Constitution says somebody who has committed a crime will be disqualified, unless the Constitution goes ahead to say that to include a foreign conviction, it is contrary to private international law. Okay? To let that have consequence in your own country. Okay? So that's the second one. If the wrongdoing is a local crime somewhere else, it's totally irrelevant. It cannot be the basis of civil recovery or civil consequences out of that country. Of course, there are some exceptions to that. There are some mutual assistance statutes, and there are some provisions related to double criminality. Okay? All these are in the field of public international law. The third one, the third ground, is if the wrongdoing amounts to infringement of foreign revenue law, you won't come to statewide to sue anybody to recover custom duties that is owed to state X. It's as straightforward as that. But what you have to understand is sometimes you need to distinguish between contractual liability and tax liability. If you are under obligation to pay money to a foreign country in exchange of a contract, maybe you breach a contract and all of that, that's not the same as you owe them tax and relocated to your country. They have to wait until you come to their country to recover their tax. They won't be able to sue you to recover it here. So there are cases on that. I think the locus classicus is the case of Holman and Johnson. You will see it in your basic text. Then the fourth ground is the one you call public policy. Public policy exception. Sometimes the substantive provision of foreign law is so insulting to the sensibility of the foreign court that the foreign court will not apply it. And in refusing to apply it, the foreign court may as well apply foreign law. The foreign court may do whatever would clean up the version that the forum has over that law. For example, countries have different approach to same-sex marriage. Some countries consider same-sex marriage so revolting to their sensibility that they have enacted laws prohibiting it. So, if you come to a country that has a law criminalizing same-sex relationship, can you now argue that, well, but we form our same-sex union in statewide, whose law permits it? You only came to your country to live. What the court is likely to tell you is that if you want a relief relating to same-sex rights, go back to that country. As a judge or a court in this country, even if connecting factor has directed me to where you are married, I will rather dismiss this case than as a court in this country where this conduct is so hated that it has been prohibited, give an order that it should be done. So, but identifying public policy is a serious matter. Okay? You will see in your complete text the case of Not and is it Not and Mohammed or whatever, where two Nigerians married under Northern Nigerian law, and the female was age, I think, 13. The age of marriage in England, I think, at that time was either 14 or 15. So somebody tried to notify the marriage. But the English court said, well, the lex noti celebrationis, the law of the place of marriage, which is also the party's domicile, prescribe the age of marriage for a woman as age of puberty. So the marriage is valid in the place where it was done. The court did not consider the matter serious enough to use public policy If he had considered public policy as an issue, he would have said, but here in England, we will not tolerate such a thing. If they want to marry at that type of, let them go back to their Nigeria. But to allow two human beings, one age 13, to be married here in UK, in the guise that the marriage was between persons domiciled abroad and conducted abroad, and we have none of it. So you see that public policies are the exclusionary excuse. It's just like what we have in customary law, the repugnancy to natural justice, equity, and good conscience. And the criticism against it usually is that it usually will depend on the hunch of the judge. So in that very case, where the English court has said, well, if in Nigeria, they will permit a girl of 12 years or 13 to marry, so be it. Another judge might say, but by our public policy, we cannot be seen validating such a marriage. Okay? So that's public policy. There is a long discussion in public policy. There's what they call relative concept. What the public policy that will be raised as an excuse will depend on time and place. Okay? It will depend on the result, the desired result that the judge wants. Okay? So, those are the 4 grounds. Since we are too many, we can divide the grounds into, we can divide them into 2. We can get someone to discuss, we can get a group to discuss pleading and proving. What is the consequence of not pleading foreign law? What is the consequence of not proving foreign law? What does the court do? The court does not throw away the case. And many Nigerian cases have made the mistake of thinking so. Okay? So that one has one paper. Then the other 3 issues. Exclusion of otherwise applicable foreign law on ground of it being a crime, on ground of it being revenue law, and on ground of public policy. But if we are still too many, we can tell some people to discuss only these 2, penal and revenue law, while others will discuss only public policy. Okay? So, class captain, let's allocate those ones too. So we can have, depending on our size, we can have either 6, 7, or 8 topics to be allocated. Okay?
Yes, sir.
Then next topic. I don't think I can finish today. I don't have stamina to talk too much.
Oh, sorry, sir. We can permit you, sir.
Or can we take the people who are Mini and Kini? Are you ready? I've not even read your paper.
I think we start presenting from next week.
Did you send the soft copy to me?
Yes, sir. I did, sir. I did
So
send
my
the
WhatsApp.
soft copy. Yes, sir. I did, sir.
Okay, I will read the topic on my WhatsApp. We will start next week's lecture with that paper. Then thereafter we move to major topic. That will be major topic 7. That is, we are talking about domicile, nationality, and habitual residence. Is that not so?
Yes, sir.
I will
Yes.
briefly introduce that one. That one is a straightforward topic. It's only one group that will take it. In fact, it doesn't need me talking. Let them go and read. So that means we already have either 9 or 8 or 7 topics, depending on our size. So by the time you allocate 555 to 9 topics, that's already 45. But if our size is not too much, you can reduce it to 7 topics or 8. Okay?
Yes, sir.
Allow me to go. I have ready.
Oh, sorry, sir. Let's permit you to go and rest, sir.
Thank you, sir.
Hello, Prof. Hello, Prof.
Yes?
Thank
Good
you, sir.
evening, Prof.
Good
I'm
evening.
sorry. I wish you good health. Prof, I'm so sorry. During the meeting, I was experiencing network glitch, and I know it's. I also have a colleague of mine who was also experienced it. I enjoyed the class, and I noticed that I've already missed out on some vital information. I was only wondering, Prof, if you don't be asking too much, if the recorded class can be shared with our class governor, I am humbly requesting, sir, so as to completely appreciate the benefit of today's lecture.
Very well. Go and ask, you know, our colleague, Mr. Olabinta, in my department, Mr.
Sir.
Olabinta. Yes, I'm sure he will have
Okay, sir.
the recording of this thing. Or
Okay,
sir.
thank you
tell
very
me
much,
what I
Prof.
can do. Can I send the recording to you from my phone? Because he told me that the thing is being recorded, but I don't know how to extract it.
Okay, very fine. Thank you, Prof.
I think the host, Mr. Olabinta, will be able to give you a record of the 2 lectures if you disturb him enough.
Okay, sir. Thank you, sir. Sir, what about is there any recommended textbook that we can use from you that can help us, sir?
Any basic first semester, any basic test. Opanga, Dokodi, Agbede, teams on essays on conflict of law, teams on conflict of laws. Morris, private international law. Then there will be articles here and there that some of us have written on a few of the topics, which we can. I used to have a small bibliography that would direct you to what you can read. Do you understand? I'll find whether I can still get those ones and send to you. Okay, but
Thank you,
basically,
Prof.
the books were. I don't have a textbook on first semester topics.
Okay,
I
sir.
have a textbook on most of second semester topics.
Okay, sir. Noted, sir.
Okay, so
Noted,
if
sir.
you buy my
Oh,
textbook, you reserve the use till second semester.
Okay, noted, sir.
Maybe one day I will summon the stamina to do a basic text on the first semester issues.
Okay, sir. Noted, sir.
Okay.
Thank you, sir.
You're welcome.
Prof, thank you for today's class, sir. Let us release you, sir.
Okay, thank you.
Thank you, sir, Prof.
Yeah, you're welcome.
Thank you, sir.
Thank you for the class, sir.
Thank you.
Thank you for the class. So, hello?
Yeah.
Yeah, so I don't know. Please let us try and assist each other in any way we can. Like as Prof said, It will try and find a way to send the soft copy to everybody, and particularly the recordings. So please, if there is anyone that has extra information or articles or editorial about the topic, please, because this is just the first class. So please let us start doing the needful till we get to mid semester or yeah, you understand. Like, and the former colleague that spoke about the recordings, I think that's a very, very brief decision. As least once I can get recordings, I'll be able to read for this week. Thank you very much, colleagues. I really, really appreciate it.
You're mostly welcome.
I think this is not the first class actually. So if we are getting the recording, if we can get the previous class, it will do well. At least so that it will help.
The
Thank
class
you.
should take notes. Yeah.
That's what he
Eh?
said already. He said so.
What's my name? What? Of what? Oh, it's because of the. I think it's because of the. There's no air escape. So I think the thing is oozing back from the. Let me please. Let me do something there, please. Hold on. Most of the time, I cover that fully.
Please, if Prof provides the recorded lecture, let's share it on the platform so that everybody will benefit, please.
Okay.
Thank you.
Can we make the Zoom now?
All right. So can we sign out, or there's any information or any more to pass on information? Hello, class rep. Class rep. Well, I think the class rep has signed out. So all the best, guys. I take my leave.
She say make I keep her, I can see on.